Welcome to our second session on role of law in society, which pertains to the course Understanding Gender in Law. The question of mapping the nature of law is tedious in nature. Genealogy of the pre-colonial and post-colonial construction of law is embedded in the conflictual realm that exists between Indian conventional laws and jurisdictional texts. The colonial and post-colonial legal transformations have impacted India in different ways. The change of law from traditional India to modern India through the conduct of colonialism determines the nature of law and society in India. Scholars of legal transformation, they have probed the nonsense of these transitions. Modernity is analyzed as an offshoot of colonialism that have impacted the majority of the people in positive fashion. However, there are scholars who argue that colonialism still exists in multiple ways in legal changes that happened in the post-independent India. So, main objective of this session is to determine the colonial and post-colonial legal transformations in Indian society and its impact. What is the ambit of law in social realm? In the first session, when we were discussing about sociology of law and sociological jurisprudence, we have given the overview of the how the sociology of law or a sociological jurisprudence approaches, how they treat law and society, what are their approaches towards the role of law in society. But what is the ambit of law in social realm? Now, Cardozo emphasized on the normative element, the regularity element, court and the enforcement as central to the understanding of law. So, some of the social scientific approaches, they have also, it is seen that they have reduced the ambit of law by defining the forces of law in terms of central authority, courts and constables, coming to the conclusion that law needs no enforcement in primitive community and is followed spontaneously. This is the view which is we can see given by the Malinowski. Therefore, the social codes reproduce the spaces and practice of values and norms and its impact on society. Social codes are categorized through its group over the manners, etiquettes, customs, etc. Each social code is operationalized through sanctions. Social spaces are constrained through social institutions. Social boycotting and isolations are central to the power structure. Now, categorization of the penal cultures through the constructions of primitive and modern needs to be analyzed in a distinctive fashion. History of social scientific understanding reveals that there were criticism against categorizing the discipline within social sciences like that of sociological understanding on law. However, doctrinal and non-doctrinal methodological dilemmas can be explored through the transformation of juridical thinking and its approach towards the sociological jurisprudence. The jurist of analytical schools such as Austin, he observed that law was the command of sovereign, and juridical empiricist school justified the unwritten and flexible law. The critiques have also pointed out that these schools oppose the efforts that deepened the understanding relating to law and societal mechanisms. It is asserted that at present as well as at any other time, the center of legal development not lies in legislation, nor in a juristic science, nor in a judicial science, but in society itself. So, Ehrlich he propounded and he asserted that no, it is that at any time or any of the time, the center of legal development does not lies only in legislation or in a juridical science, but the main focus should be society itself. Understanding of social legislation is judged through its impact on personal laws. It also acceded how it is received in highly retrogressive social political spaces. Complexities of such are not so easy transitions which have tried to capture through the epistemic approaches. Scholars therefore return to quandaries related to legal knowledge. How dominant social scientific understanding captures these these nonsense relating to law, but it seems that sociological understanding of law still has no clearly defined boundaries. Its various exponents are not in agreement as to its subjects or the problem of requiring solution or its relation with the other branches of the study of law. This is the view which is given by Gavich. So, they are not ready to accept that or not in agreement with each other. There are various exponents that maybe when we are talking about in relation with other branches of the study of law. Now, if we have to determine the efficacy of implementation of law, social legislation in Indian society, there has been many there are various scholars' view available on that. Now, cynicism related to the modern legal institutions among the people, it has provoked scholars to think whether the degree of success of implementation of law and efficiency of the functioning of legal system in India do not seem to have studied systematically and adequately by the socialists so far, nor has the impact of social legislation empirically. This is the views by the given by the Indra Deva. It is analyzed by Deva in book Sociology of Law that post-colonial India does not seem to have appreciably from what it was during the British rule. So, foundation of this legal system were laid around 1860 when such basic laws such as civil procedure code, the criminal procedure code and the law of evidence was put in place. Some of the proclivities of the 14th report of Law Commission on reforms of judicial administration earlier which was given, they pointed out that certain deficiencies in the legal system at that time. It highlights that large chunk of people in India were ignorant about the basic laws, and still today also many basic laws, many of the people are not aware of the basic laws, legal systems and procedures. In addition to this, the language which is deployed in High Court was hardly understood by the majority of the people. The technical aspects are emphasized in lawsuits than the substantive facets of the disputes. So, these were deficiencies which is pointed out by the 14th Law Commission report, which further says that lawyers and courts are more inclined to the protraction of litigation than the settlement of disputes. Innocent peoples are oppressed by the dominant sections through their appropriation of the court realms, and further it leads to the diffidence in the innocent people. Majority of the people cannot afford the legal services because of the high fees of lawyers. It was pointed out that issues related to excessive litigation or a backlog of pending cases and detected nature of causes related to perjury and forgery. Still in the modern India also, in the now also, presently also, though legal services have been provided by attempts have been made by the government to provide free legal aid and services, but still there is so much of litigation and it still takes much time to resolve any dispute which goes to the court. So, it takes lots of time. It was further observed that a pernicious feature that has come to the force in the post independence race, that of enacting too many laws and subjecting them to numerous amendments from time to time. This has created a thick jungle of laws that it is difficult for anyone to find his way. So, these are the views of Deva. He says that there are so many laws and so many amendments coming time to time, it becomes like a thick jungle where we have to look for way. So, therefore, establishing a meaningful and efficient communication networks between the legislation, the judiciary and the public is essential task in which work in the field of sociology can contribute a great deal. The various social scientific understandings, they emphasized on inclusion of sociology of law in the field of legal reform. There are various other issues also, like one is whether there are connections still persist between British Indian legal system and Indian legal system. Now, if we look into the views of various scholars like one of Upendra Bakshi, who analyzed the anxieties of hegemonic sections related to such legal transactions or legal transitions as a part of vested interest in dominant power structures. Dependence autonomy were explored as a colonial baggage autonomy on relation to such transitions. Now, culture of protest and disobedience, according to Bakshi, was central to the legal constructions. It is further observed that top to down model is part of British Indian legal system, which is Austinian type, and it created its own trajectories. Further, the law making remains more or less the exclusive prerogative of a small cross section of elites. This necessarily affects both the quality of law enacted and its social communication, diffusion, acceptance and effectivity. It also reinforces the highly centralized system of power. Thus, Indian legal system also follows the colonial model of reactive mobilization of law rather than the proactive mobilization. Now, in the former British Indian legal system, the citizen is left to initiate the legal process by filing the complaint. In the later, the state agencies initiate the legal process. Laws that attack certain segments of social structure in the title of justice and equity obviously needs the proactive mobilization. As per the Bakshi, access to law means not just access to courts, as the lawyers generally think about it. It means in a broader and socially more relevant sense, access to lawmakers, to dispensers of legal services, that is legal professions, and to normative and institutional information concerning the legal system. One of the view of J. Duncan Amderet is also plays a very important role, who demonstrated the struggles of the British administration and their tedious engagement with the orthodox realms of Shastras. Rights related to revenue matters impacted the diverse group of colonizers. It resulted in the intellectual gap between judgments delivered in the high courts, where some judges were English barristers standing, and the country wakils who were supposed to advise their clients according to them was, and to large extent remains marked. Who further observed that judicial hierarchy was developing a striking dichotomy emerged between court law, popular law, interacting components we have already observed for somewhat earlier period. So, Deret also explored the dominant Brahminic culture that impacted the administration. The Hindu system gave everyone his place in every possible contingency. Individuals was not prized, functions were fixed by caste system, and source of pressure outside the violent barely Hinduized tribes were many. The co-option of the dominant caste and the interplay of homogeneity and heterogeneity of communities connected law were explored by Deret, and it is linked to the misunderstanding of law from the outside and indigenous understanding. Deret though tried to unfold how these legal transitions resulted in gradual decay of personal laws. The psychological hiatus created through the perception of foreign and native law was also analyzed in this context. So, gradually it resulted in the confluence of English type laws and personal law. Legal authority of Shastras was central to such legal transformation. So, earlier if we look into the earlier period, so legal authority of Shastras was central to the legal transformation. So, it has led to the clash between textual laws and non-textual customs. Bakshi observed that normative law is virtually inaccessible to the most underprivileged and vulnerable groups of Indian society. Legal illiteracy of beneficiaries of law thus contributes to its ineffectiveness. Citizens' access to legal services as analyzed in relation to their consciousness about the legal levels and substantive interventions. So, profit oriented approach of the lawyer was analyzed as continuity of colonial insistence related to exorbitant court fees. In the context of depressed sections, social legislation seems to remain primarily symbolic and ritualistic. It is doubtful whether it has been successful in reaching its objective. That Deva has in his book cited in Sociology of Law that it is doubtful whether it has been successfully achieved their objectives. So, land reform laws, for example, they suffer from some weaknesses. And it is not only many social legislation laws were formed by the government in modern context also, in now also there are so many acts which provides for the equality of justice to all the sections, even and the focus is also on the depressed section, but the actual effect of those legislation is still yet to be achieved. Justice V.R. Krishna Iyer, he observed that rather we must not only tighten our nuts and bolts and press the accelerator, but redesign the project to replace a ramshackle machine. The renovation and reorganization of judicial setup involves the sophistication of the machines, incorporating modern advances and technical knowledge, so that delay killing devices may harmonize with better functional performance. The harmonization of the system may find application in judicial process. The former President K. R. Narayana, he has once observed that it is important to simplify the legal procedures involving litigation and the disposal of cases. Law delays are proverbial, and it is in this field that reforms are urgently needed, not only to reduce the mounting cost of litigation, but also to see that justice is not denied to people. Decline of sound legal culture is due to the lack of political will. Flexibilities, so loopholes, they are becoming impediments for the effective deployment of legal institutions and practices. However, the role of law as an instrument of social change cannot be denied. Law being the reflection of the will and wish of the society. And if one wants to study any society, one has to study that law enacted by that society to know whether the society is developed or wildward. So, the law, though it is a product of society, is responsible for social transformations, and it do play an important role in social change. For example, the Untouchability Offences Act, the Hindu Code Bill, the Sarda Act, the Prohibition Act, they are examples in this context. One great merit of law is that it adapts itself to the changing need of the society and maintains stability with the rapid alterations disturb the relation in society. So, law helps the society to assimilate the changes by adjusting group advantages and injuries resulting from them. Therefore, the law may become an advanced instrument of social change on national as well as international level by affecting the social framework in which relation takes place. Law, and especially legislation, is a vehicle through which programmed social evolution can be brought about. No doubt that the role of law in a society cannot be challenged, and it is a means of social transformation. But now if we see, the sovereignty has been also questioned in the age of new global institutions and world peace through law. The colonialism and post-colonialism has become the keywords of contemporary scholarships on society and law. Eurocentric approaches are being criticized through the schools such as third world approaches to international law. Imperialism and larger questions of immigration or emigration have also become a part of current social debates, current social legal debates. It is also criticized that the more sociologists of law, like any other empirical scientist, ignore the demand of pure science in order to produce socially relevant results, the more funding they will get for their research, but less they will contribute to the theoretical progress, and hence to only really think a science can bring forth. So, this were cited by the Griffiths in 2017. So far we have looked into the impact of legal transformations which are going in the colonial and pre-colonial period, or a post-colonial period, and there were the views of the various scholars which pointed towards the lacunas in a legal system and how sociology of therefore we can say it is a need that sociology of law and the sociological jurisprudence, and they should work in a manner that law can become an important role in bringing change in the society. And though it is law is very effective and it changes with the changing needs of the society, and economic life of society needs to be understood through sociology of law only. The sociological research on law and economy should concentrate on social networks and regulations and the notion of social behavior that impinge law and economy. So, it is suggested by James S. Coleman that the path in research and in the theory development that will reconstitute relevance of each for the other requires firstly the use of theory of purpose section as central to the social theory that entails acceptance of methodical individualism and rejection of holism, and secondly a shift of social theory and research from individual actions to that of macro social functioning. So, role of law in a society is very important and it needs to be understood through sociology of law. Thank you.